Ladies and gentlemen, it's a delight to see you here, and I hope to provide some diversion from the other events of the day. It is a privilege and a pleasure to give this lecture. First, because of the long history of contact between Gray's Inn and the Inns of Chancery, of which Barnard's Inn was one. For that matter, Sir Thomas Gresham, who founded Gresham College, with respect to Dickens, these lovely surroundings where we are today, was a student of Gray's Inn in 1597. Secondly, because it is a delight to see an ancient tradition again flourishing. There was something of a gap between 1675, when the last reading was given, and 1996, when the tradition was revived. Thirdly, because of my very distinguished predecessors who have given this reading in recent years. Old tradition though it may be, inevitably some things do change. Until about 10 years ago, the speaker apparently processed down High Holborn in a gown with a head porter clearing the way. Unaccountably, that did not happen this evening. Times change. And changes in judicial leadership. Change is my central theme tonight. It is one that has a number of facets, in court and outside of court, all vital to the success of our justice system, both domestically and internationally. The range and extent of judicial leadership activity is striking. Some aspects are traditional, of very long standing, and taken effectively for granted. Others involve little short of a sea change. There is no reason whatever to suppose that the need for judicial leadership will diminish. In some areas, it may well increase. The aspects of judicial leadership I wish to explore are these. First, developing the law. Secondly, developing procedure, case management. Thirdly, reform of the justice system, HMCTS Reform. And fourthly, domestic society and foreign relations. Before turning to these issues, let me be clear about one matter. The most important task for every judge is trying cases or hearing appeals. Securing justice as between the parties to litigation is the central, irreducible core of the judge's role. We must not and do not forget that. But tonight, I seek to look beyond that primary and essential task. I should, however, state the obvious. The views I express this evening are my own. The notion that as a judiciary we have one view on any topic is, of course, risible. I also do not wish to fall foul of the stricture attributed by Churchill to Balfour. Commenting on a speech, Balfour remarked that in part it was true and in part it was trite. That which was true was trite, that which was not trite was not true. Developing the law. At first blush, the central feature of our uncodified constitution, parliamentary sovereignty, might suggest that developing the law is a matter for Parliament and not the judiciary. No leadership role for judges, you might think. Such a view would fail to appreciate the genius of our common law system, and that our Constitution has always accepted that the courts have as central a role in the development of the law as Parliament, subject to Parliament's constitutional right to amend, revise, or correct the common law through statute. How? What method do the courts use? The answer to that has most recently been furnished by Sir John Laws in his outstanding 2013 Hamlin Lectures, published as the Common Law Constitution. In short, the courts develop the common law through a fourfold method: evolution, experiment, history, and distillation. Here lies its genius. It is not static, the product of a moment in time. It is capable of evolving as society and its needs, mores, and conditions evolve. It is capable of developing in new, previously untried ways. If they work, they are built on. If not, they are not, and further change can be made. As Lord Judge put it recently, in the common law, it has been accepted for 1,000 years, indeed it is of the essence of the common law, that judges may develop the law by applying its fundamental principles to new conditions and declaring them. What has the common law method produced? For that, we look to our body of case law. Anyone looking at any area of our law will see the extent to which the courts have led the way, developing, shaping, and refining the law. Contract, commercial contracts, shipping, insurance, international trade, the work in progress on restitution, the development of civil rights, long predating the Human Rights Act, the list goes on. The broad point is this: there is little to no area of our law that is not the product of judicial decision-making, resulting in a system of law that is capable of adapting to the needs of a changing society. As such, it calls for creativity, judgment, and sometimes restraint. In the latter regard, it is sometimes helpful to see ourselves as others see us. As Professor Anthony King has recently put it in a book called Who Governs Britain, the courts have been innovators, but in a tempered way, one which has seen them, quote, given half a chance, inclined to render unto Parliament the things that are Parliament's, close quote. This is perhaps not always straightforward. As a consequence of the enactment of both the European Communities Act and the Human Rights Act, both of which led Professor King to the following observation, quote, if the position of the courts has become controversial, it is overwhelmingly because Parliament has invited judges to make controversial decisions. Parliament has chosen to outsource to the courts a good deal of its power. That's the end of the quote. Difficult decisions need to be taken as to striking the right balance. The more that controversial areas are outsourced to the judiciary, the greater the challenge for individual judges and judicial leadership. My second major heading, developing procedure, case management. I turn to this area the means by which justice before the courts is secured. The judiciary's role in formal procedural reform can be traced from, at the least, Lord Eldon, who chaired a Chancery Reform Commission in the 1820s. More recently, we are all familiar with the Wolfe, Jackson and Briggs reforms to civil procedure and the Leveson reforms to criminal procedure. One of the most significant recent areas of judge-led reform has been the introduction of active judicial case management across all our jurisdictions from the late 1990s, a reform which, as a former Master of the Rolls noted, Lord Eldon's commission may well have suggested should be introduced in the 1820s, albeit it took some 180 years to take hold fully. Although I confine myself tonight to civil and criminal case management, probably more on the criminal side, it can safely be said that case management is now embedded in all our jurisdictions. It is difficult to overemphasize the cultural sea change which has taken place in this regard, though the progress which has been made could not have occurred without the active support of the professions and the other agencies involved, for example, the police and the CPS in the criminal sphere. It would not have happened without active, determined, and sustained judicial leadership. I begin with the sea change. Traditionally, the role of the judge in court, at least at common law, was essentially passive, acerbic interventions aside. As the two great legal historians, Pollock and Maitland, put it, the behavior which is expected of a judge in different ages and by different systems of law seems to fluctuate between two poles. At one of these, they wrote, the model is the conduct of the man of science, who is making researches in his laboratory and will use all appropriate methods for the solution of problems and the discovery of truth. At the other stands the umpire of our English games, who is there not in order that he may invent tests for the powers of the two sides, but merely to see that the rules of the game are observed. It is towards the second of these ideals that our English medieval procedure is strongly inclined. We are often reminded of the cricket match. The judges sit in court, not in order that they may discover the truth, but in order that they may answer the question, "How's that?" This passive habit seems to grow upon them as time goes on. Well, there was limited scope for pre-reading, and the parties set the pace. Within very generous limits, the conduct of the trial was in the hands of the parties' legal representatives, subject, of course, to directions or rulings on the law. Because of case management, now codified in all our procedural rules, that description is no longer recognizable. It and the philosophy which underpins it are taken for granted in civil proceedings generally, as well as specialist jurisdictions such as the commercial court, where it has long been the practice, in family proceedings and in criminal proceedings. The judge now grips the case, both pre-trial and at trial. Examples are readily to hand. I confine myself to those from criminal cases, where, for instance, trial by ambush is largely a thing of the past, and the interminable and repetitive cross-examinations will not do, the more especially when the complainant, victim, or witness is vulnerable. The culture change in criminal proceedings has been particularly striking. The rationale was outlined by Lord Justice Judge, as he then was, in a case called Jisl, J-I-S-L. Quote, "The starting point is simple. Justice must be done. The defendant is entitled to a fair trial, and, which is sometimes overlooked, the prosecution is equally entitled to a reasonable opportunity to present the evidence against the defendant. It is not, however, a concomitant of the entitlement to a fair trial that either or both sides are further entitled to take as much time as they like, or for that matter, as long as counsel and solicitors or the defendants themselves think appropriate. Resources are limited. The funding for courts and judges, for prosecuting and the vast majority of defense lawyers is dependent on public money, for which there are many competing demands. Time itself is a resource. Every day unnecessarily used while the trial meanders sluggishly to its eventual conclusion represents another day's stressful waiting for the remaining witnesses and jurors in that particular trial, and no less important, continuing and increasing tension and worry for another defendant or defendants, waiting their turn to be listed. It follows that the sensible use of time requires judicial management and control. The criminal procedure rules now enshrine and reflect this philosophy, requiring cases to be dealt with justly, taking account of the need to conduct trials efficiently and expeditiously, the need to be fair to parties, victims, witnesses, and jurors, and to acquit the innocent and convict the guilty, requiring the court to manage cases actively to that end, and requiring the prosecution and defense to ensure that they assist the court in the active case management process. Pausing here, it may be observed that the art of case management is more complex in criminal cases than in civil cases. The reason is simple. In a civil case, remedies by way of costs, summary judgment, or strikeout are ordinarily amply sufficient to deal with a recalcitrant party. For obvious reasons, the question of sanctions in criminal cases is much more problematic. It is, in fact, a continuing source of concern and unfinished business. Even so, case management is now just as firmly a part of the culture in criminal cases as it is in the civil and family jurisdictions. Judicial work in the area of case management has been extensive. I highlight, if I may, three major exercises in which I have been privileged to have had some personal involvement. The first is disclosure in criminal cases, and especially cases where vast quantities of electronic materials have been generated. The principal and grave concern was that the burden of disclosure should not render the prosecution of economic crime impractical. The upshot was a review which I conducted, together with a further review which I conducted with Lord Justice Tracy. For present purposes, the judicial role in case management was emphasized in the judicial protocol, which incorporated the recommendations of the review. Judges now have the power and the duty to manage disclosure actively and robustly in every case. The perception that this was a matter to be resolved between the parties was wholly out of date. The relevant principles relating to this most important case management exercise, crucial in large cases for giving effect to the overriding effect of the criminal procedure rules, have now been given effect and the force of authority by a specially constituted Court of Appeal in a recent case called the Crown and R. In a nutshell, the culture has changed, and it has changed because of judicial leadership supported by professional best practice. Transforming summary justice. This was an initiative, a criminal justice system-wide project implemented nationally in May 2015. It reflected the conclusions more or less simultaneously reached by the Judiciary following a review of disclosure in the magistrates' courts and the CPS and police as to the need for improved efficiency in magistrates' courts. Transforming summary justice, TSJ, aims to enable guilty pleas to be taken and dealt with in one hearing, and for contested cases to be properly case managed at the first hearing, actively progressed thereafter, and disposed of at the second hearing. It has called for a fundamental change by the CPS and the police, involving the front-loading of work to permit early review of cases and their division into those where guilty pleas are anticipated and those where not guilty pleas are anticipated. Importantly, TSJ, Transforming Summary Justice, was implemented by way of joint working and close cooperation between the Judiciary, the CPS, and the police. Learning from previous experience of judicial initiatives, we have put in place a continuing governance structure, having regard to constitutional principle and practical reality. The structure involves parallel arrangements for the Judiciary on the one hand and the CPS and police on the other. In this way, regular performance monitoring has been established. These are still early days, but the initial signs are promising. Better case management, not a very original acronym or title, BCM, relates principally to the Crown Court, whereas TSJ relates principally to the Magistrates' Court. BCM started in 8 early adopter Crown Court centres in late 2015 and was implemented nationally from the 5th January 2016. It is incorporated in the criminal procedure rules and the relevant criminal practice direction and brings together a number of complementary initiatives, including the introduction of a nationally uniform early guilty plea scheme and in document-heavy cases, the work to which I have already referred on disclosure. The aim, simple, to dispose of guilty pleas as early as possible and manage those cases destined to go to trial robustly. Wherever possible, the number of pre-trial hearings will be reduced to the benefit of all concerned. Again, as with TSJ, there's been an intense focus on implementation involving the closest cooperation between Judiciary, CPS, the police, and the engagement of the professions. Implementation has been national and local. Continued judicial governance is again a feature. In terms of overall coherence, because we, like any system, have to guard against too many initiatives at any one point in time, initiative overload, but in terms of overall coherence, the implementation of BCM dovetails with and forms a part of the implementation of the Leveson Review. As will be obvious, these are very early days, but the response from all concerned has been encouraging. Pulling the threads together, I underline the culture change under judicial leadership, which has seen case management embedded in all jurisdictions. While at its simplest, case management is applied common sense, with a continuing emphasis on identifying the issues, evidential requirements, case progression, and timeliness. This has been a vast effort. The judiciary could not have done this on its own, but judicial leadership has been critical. We have sought to learn from the past in our focus on planned implementation and continued governance. We have also devoted attention to ensuring that appellate courts support robust case management by judges at first instance. In terms of using available resources efficiently, clearing the decks, and providing an improved public service, the importance of case management cannot be overstated. I turn to my next heading, Reform of the Justice System, HMCTS Reform. Judicial leadership is not confined to developing the law, procedure, or case management. But let me put this in context. Prior to 2003, the Lord Chancellor was head of the judiciary, and administration was very largely in the hands of the Lord Chancellor's department. In the event, the Constitutional Reform Act 2005 saw the Lord Chancellor shorn of his judicial role as well as the speakership of the House of Lords. To the Lord Chief Justice went the leadership of the Judiciary of England and Wales, as well as a vast swathe of powers and responsibilities that previously lay with the Lord Chancellor. The Lord Chancellor's Department became the Department of Constitutional Affairs, for a while fondly known as DCAF, and then in 2007, the Ministry of Justice. These reforms have been of profound significance for the judiciary. On the one hand, they have provided a greater degree of constitutional and institutional independence from the executive than was previously the case. Now we have a quasi-department, the Judicial Office, which provides the administrative and policy support to the Lord Chief Justice, fulfilling a significant amount of the work that the Lord Chancellor's Department would once have carried out. And the Lord Chief Justice represents the judiciary's views to the government and Parliament. On the other hand, the judiciary has become subject to greater scrutiny and without the previous political shield and representation that the Lord Chancellor used to provide with a senior voice in Cabinet. Another consequence has been the emergence of what I think is unique in our constitutional framework, Her Majesty's Courts and Tribunals Service, HMCTS, the body that administers the courts and tribunals. I say unique because it is a partnership between the Lord Chancellor and the Lord Chief Justice and the Senior President of Tribunals, thus a partnership between the executive and judiciary. The upshot, which cannot be underestimated, is the massive expansion of judicial leadership, management, and administration roles. The, quote, day job, close quote, in court is now just the tip of the iceberg. As Lord Judge noted, all this adds greatly to the interest of the job, but the time in which to do it does not increase. It would be a very long lecture indeed if I dealt in any detail with the proliferation of judicial leadership roles and what each entails. It suffices simply to mention the Judicial Executive Board, that is the Lord Chief Justice's cabinet in effect, the Judges' Council, the Master of the Rolls, heads of division, the Senior President of Tribunals, Vice Presidents of Divisions, the Senior Presiding Judge and Deputy Senior Presiding Judge, the Chairman of the Judicial College, the Presiding Judges, Family Division Liaison Judges, Chancery and Administrative Court Liaison Judges, Resident Judges, Designated Civil and Family Judges. The list could easily continue, and I have not even touched upon leadership roles in the tribunals. In my role as Senior Presiding Judge, 2013 to 15, I had the privilege of a unique vantage point from which to observe and in many ways to help shape the changing demands now placed on judicial leadership. Had we an organization chart, it would show that the presiding judge's reporting line is to the SPJ, who is largely responsible for the administration of judicial business in the courts outside of the Royal Courts of Justice. The SPJ is involved in deployment, promotions, training, and sadly from time to time, health and disciplinary matters. He also, and it's a most rewarding part of the role, is responsible for liaison with the magistracy. The SPJ works very closely with and reports directly to the Lord Chief Justice. He is a member of the Judicial Executive Board and has a seat ex officio on the HMCTS board. He is often the first port of call for dealing with government departments and policy initiatives in both the criminal and civil jurisdictions, and none of this should be thought of as downplaying the importance of and demands on the Senior President of Tribunals, Master of the Rolls, heads of divisions, and other members of the JAB. I am simply offering a perspective based on my own experience. The SPJ has regular, ordinarily daily contact with senior officials of HMCTS. There is no doubt that the role of SPJ is a significant, demanding leadership role at the center of our justice system, and so far I have only described business as usual. Validating Macmillan's observation as to events, yet again, three additional matters loomed largest in my time in office. First, HMCTS Reform, of which the Lord Chief Justice once memorably said it would take more than 100% of my time. Secondly, performance. And thirdly, support for judicial leadership roles. Because of it being a truly once-in-a-generation opportunity, I want to devote most time to HMCTS reform, but performance and support for judicial leadership roles are both of such importance that I must mention them and do so first. Performance does not, of course, mean outcomes in individual cases. That is a matter for the judge concerned, subject only to the appellate process. Performance does mean doing what we can as a judicial leadership to ensure that courts operate efficiently, making optimal use of the limited resources available. In the county court, for example, a focus on performance entailed devising new management information, replacing a plethora of unfocused data. It was a paradigm example of joint working between the judiciary and HMCTS officials. In the magistrates and Crown courts, the TSJ and BCM initiatives of which I have spoken could not take root without a judicially led culture change, emphasizing the relevance and importance of improved performance. Getting a grip on performance, which we now have more than ever before, has involved a very substantial exercise in judicial leadership. I should add that none of it can be accomplished by diktat from the senior judiciary at the Royal Courts of Justice. It requires and has obtained support from the judiciary at all levels around the country, who have overall proved notably willing to embrace change, subject to very understandable and proper probing of the practicalities involved. Support for judicial leadership roles was a topic which very much developed during my time in office. Much assisted by the views of resident judges, presiding judges, and others, we realized, not before time, that we could no longer simply leave those in leadership roles to their own devices, and the benefit of encouragement from the senior judiciary. The demands were simply too great, not least at a time when frustrations over pay and pensions, to which the Lord Chief Justice has recently alluded, have threatened judicial morale. It is important to realize that, unusually at least, most of our leadership roles are not rewarded with a salary increment. And here I pause to pay a warm and grateful tribute to some of the true heroes of the system. Up and down the country, resident judges and designated civil and family judges, for no extra pay, display conspicuous leadership skills in dealing with judicial colleagues, court staff, and others to keep the system afloat. Absent salary increments, we have implemented arrangements across the jurisdictions for both time out of court and administrative support. Neither is an indulgence. Both are necessary to enable leadership judges to fulfill their roles. Additionally, a more complex world has meant that while still very small in number, and it's important to maintain perspective, time-consuming, sometimes corrosive, and emotionally draining HR issues have been on the increase, requiring early recognition and intervention by leadership judges. We have taken steps to provide leadership judges with the relevant training and support, including much-wanted leadership training, although I apprehend that there is still some way to go. HMCTS Reform. Following years of salami-sliced reductions in resources, it has been apparent from at least late 2012, if not before, that strategic reform was an imperative. The only alternative, let me emphasize that, was decline. Reform has proved as daunting as it is exciting, truly a once-in-a-generation opportunity to provide an improved justice system. Subject, of course, to the Lord Chief Justice and the Judicial Executive Board, the SPJ has been the judicial lead on reform. In my time, Lord Justice Fulford, then my deputy, now the current Senior Presiding Judge, led on IT, and the Senior President of Tribunal has throughout occupied a pivotal position. HMCTS Reform, put simply, involves an integrated program with three strands. First, transforming our IT. Secondly, modernizing our estate. Thirdly, changes to our working practices. To emphasize, this is a transformational program, truly so called, and an integrated program, with the support and agreement of both the Treasury and the Ministry of Justice and successive Lord Chancellors. Funding of some 700 million plus has been agreed. Moreover, the Treasury has agreed various flexibilities and the ring fencing of the proceeds of asset sales, so these can be reinvested in the program. It needs to be emphasized at once, as the Lord Chief Justice has put it, that this is not reform done to the judiciary. Quite the contrary. HMCTS reform can only be successfully accomplished with judicial participation nationally, at circuit level and locally, and hence the establishment of local leadership groups. By its nature, much of the program must be judicially led. Because of the need for engagement by the judiciary across the country, much judicial leadership time has been invested in roadshows. Well, Justice Fulford and I took part in more than 30 in 2015. Communication between the SPJ and judges across the country is an essential part of the process. Judicial involvement and leadership must also be jurisdictionally based. Proposals for reform must satisfy those with practical experience of the jurisdictions in question. That is the way to test ideas. For this reason, judicial engagement groups were established and have already and repeatedly proved their worth. Even this brief outline of the reform program serves to illustrate the sheer scale of the judicial leadership task, perhaps best exemplified, if I may say so, by the tireless commitment, drive, and energy displayed by the Lord Chief Justice personally to ensure its progress. That said, judicial leadership is a necessary but not sufficient condition for success. HMCTS reform could not be accomplished without the closest cooperation between the Judiciary and HMCTS, involving the complete commitment of the HMCTS senior management team, together with support and guidance from the HMCTS board under its universally respected and independent chairman. Significant progress has already been made. The reform program is real. It is not aspirational or theoretical. By way of examples only, our criminal courts are now largely equipped to work digitally. For certain traffic offences, there is the facility for online pleas. I'm not going to suggest you try it out. The first automated rotors for magistrates have been introduced. The rationalisation of the estate has begun with the close and continuous involvement of the judiciary nationally and locally. This is exciting. It is also, as I have said, daunting. We do need to get it right. If we do, it will be a legacy for the future, both for the judiciary and a reforming Lord Chancellor. The foundations are sound. We need to press on and implement the programme as a whole. My fourth and final major heading, domestic society and foreign relations. I only touch on these. Time does not permit any more. They are largely the preserve of Parliament and the executive, but we do have a role. First, domestic society. It is axiomatic that the two primary functions of the state are defence of the realm and the provision of law and justice. If the state succumbs to its external enemies, all is lost. If it does not uphold law and justice, no other rights can be enforced or entitlements enjoyed. Against this background, it is impossible to overestimate the importance of the rule of law and an independent judiciary to our society. As often said, the judiciary is the guarantor of the rule of law, and as such, its domestic role is crucial. It serves to define the society we are. Here, too, there are significant leadership demands, calling for principled but finely tuned judgment. The key point is that the judiciary is not simply another group of senior officials. It is a branch of the state distinct from and independent of both Parliament and the executive. The task of the judiciary and its leadership is demanding. It is to achieve the right combination of judicial fearlessness and independence with an appropriate sense of restraint, recognizing and respecting the proper sphere of the other two branches of the state. Not entirely straightforward, then. What it plainly calls for, to adopt Lord Judge's word, is fortitude, fortitude from individual judges and from the judicial leadership. Foreign relations. English law and our courts and arbitration tribunals are world leaders. It follows that, subject to constraints, budgetary time, and the proper limits of judicial conduct, our judiciary has a significant role to play in this sphere, and the task of judicial leadership is to set the goals and prioritize accordingly. The unifying principle for the judiciary here is upholding or building the rule of law internationally. In part, this role involves working in the national interest in coordination with the Foreign and Commonwealth Office. The judiciary cannot freelance on foreign policy, while of course preserving judicial independence throughout. In further part, this principle complements underlining and promoting the leading role of English law internationally and London's world leadership in dispute resolution. Our approach in this latter regard should be principled and should seek to build comity between courts, as flagged by the Lord Chief Justice's recent initiative to establish a worldwide forum of commercial courts. Let me now pull some conclusions together from this discussion. First, the leadership demands on a good many judges have changed beyond recognition. As I have suggested, judicial leadership is a necessary condition for the culture change achieved in case management and the success of the reform program, also for getting a grip on court performance. All this is in addition to the role taken for granted in developing the law, in helping to define the society in which we live, and seeking to boost the rule of law, English law, and London internationally. Still further, the judiciary's leadership role now requires engagement to a significantly greater extent than in the past with the executive and parliament. The range and scale of judicial leadership is striking, but every additional leadership demand on judges comes at a cost in terms of time and the need to deal with cases in court, not to mention the pressures on individual judges. Hard choices need constantly to be made. We do not want our most senior judiciary to become detached from the business of judging, but extensive involvement of the same group is indispensable to shaping the justice system of the future. Putting it bluntly, there is currently no substitute for judicial leadership in the areas it now covers. Secondly, I cannot foresee any lessening in the demands for judicial leadership, and the opposite is more likely to be the case. There is no going back to a more closeted world, and therefore no easy answer to ensuring the right balance between time in court and leadership time out of court. Realistically, and for the time being at least, we may need to accept this feature of judicial life and structure senior roles accordingly. Thirdly, one measure which should assist would be a significant strengthening of the support available to the Lord Chief Justice, the Judicial Executive Board, the Senior Presiding Judge, and other leadership judges. This is not and should not be misinterpreted as a criticism of officials currently in post. It is instead setting a new benchmark. In my own experience as both presiding judge and SPJ, I have had the pleasure of working closely with a number of officials who can truly be described as excellent, and what a difference that made. But if we are to free judicial leaders from some of the work which currently, and in my view necessarily, falls upon them, then we should be exploring a step change in the support available. A number of role models of what we might want are readily spring to mind from both the Judicial Office and HMCTS. Fourthly, to be clear, one variant which we must at all costs avoid is a model where, quote, managers rather than judges hold sway. Unfairly or not, that is the perception many have of the NHS, a perception that clinicians answer to managers rather than vice versa. Managers answering to judges, subject to appropriate public accountability, is one thing. Judges being directed by managers is another, and in my view at least, would be flatly unacceptable. Fifthly, the judiciary's extensive involvement in leadership means that we are entitled and bound to think more about the optimal structure for the justice system as a whole, and in particular, whether the constitutional reforms of 2005 and the following years comprise an unfinished journey. Is it right that HMCTS should form part of a larger ministry which has responsibility for prisons? Would the governance arrangements of HMCTS, and hence the reform programme and our ability to implement it, be simplified and improved if HMCTS reported to a single shareholder, namely the judiciary, rather than both the executive and the judiciary? Would that assist in attracting dedicated, high-caliber support for the judicial leadership from HMCTS, which would reduce the burden on the judiciary that I have sought to describe? What governance, budgetary, and accountability mechanisms would need to be put in place? None of this is novel, still less heretical internationally. Is there attraction in a system such as the US, where the Administrative Office of the United States Courts supports the federal courts and is independent of the executive branch? Likewise as to Scotland, where the creation of the independent Scottish Court Service has led to the transfer of the authority for the administration of the courts from the executive to the judiciary. It is said that the mindset has altered, and for the good. While such considerations should not, indeed must not, distract all concerned from the immediate imperative of implementing the reform program, I would be surprised if we avoided discussing them in the future, not least because they have a very considerable bearing on the framework within which judicial leadership operates. We live in interesting times. They make for a more interesting, if more demanding, judicial world, one that calls for more reflection on judicial leadership and what it means in the 21st century. Thank you.